Hi, good evening, everyone. My name is Nell Pepper, and on behalf of Harvard Bookstore, I am so pleased to introduce this virtual event with Judge Jed S. Rakoff, presenting his book, Why the Innocent Plead Guilty and the Guilty Go Free, and Other Paradoxes of Our Broken Legal System, in conversation with David B. Wilkins. I hope you're all well and safe. Thank you so much for joining us virtually tonight. Through virtual events like tonight's, Harvard Bookstore continues to bring authors and their work to our community and to our digital community during these challenging times. Every week, we'll be hosting events here on our Zoom account. And just like always, our event schedule will appear on our website at harvard.com, and you can sign up for our email newsletter for more updates. This evening's discussion will conclude with some time for your questions. If you have a question for our speakers at any time during the talk tonight, click the Q&A button at the bottom of the screen and we'll get through as many questions as time allows. In the chat, I'll be posting a link to purchase copies of Why the Innocent Plead Guilty and the Guilty Go Free on harvard.com, as well as a link to donate in support of this series and of our store. Your purchases and financial contributions make events like tonight's possible and help ensure the future of a landmark independent bookstore in Harvard Square. We thank you all so much for showing up and for tuning in support of our authors and in support of the fantastic booksellers at Harvard Bookstore. We sincerely appreciate your support now and always. And finally, as you may have experienced in virtual gatherings, technical issues might arise. We hope they don't, but if they do, we will do our best to resolve them quickly. And we thank all of you for your patience and understanding. And now I am delighted to introduce our speakers. Judge Jed S. Rakoff is a senior judge of the United States District Court for the Southern District of New York and an adjunct professor at both Columbia University Law School and New York University Law School. He is a regular contributor to the New York Review of Books. In 2014, he was listed by Fortune magazine as one of the world's 50 greatest leaders. David B. Wilkins is the Lester Kissel Professor of Law, Vice Dean for Global Initiative on the Legal Profession, and Faculty Director of the Center on the Legal Profession at Harvard Law School. Professor Wilkins has written over 80 articles on the legal profession in leading scholarly journals and the popular press, and is the co-author or editor of 5 books. Tonight, they'll be discussing Judge Rakoff's new book, Why the Innocent Plead Guilty and the Guilty Go Free, and Other Paradoxes of Our Broken Legal System. Grounded in Rakoff's 24 years as a federal trial judge in New York, in addition to the many years he worked as a federal prosecutor and criminal defense lawyer, Rakoff's assessment of our justice system illuminates some of our most urgent legal, social, and political issues. Publishers Weekly writes that Judge Rakoff debuts with an excoriating and exceptionally knowledgeable analysis of flaws in the U.S. justice system. He builds his case with precise evidence and clear intent. The result is a persuasive and practicable call for reform. I'm honored to turn things over to our speakers. The digital podium is yours, Jed and David.
Thank you. Thank you, Nell. Thank you so much. Before we go any further, really want to thank the Harvard Bookstore and to urge everyone listening to support this great institution. I've been teaching here at Harvard Law School now for, I hate to say, 36 years. And I was a student many years before then. And the Harvard Bookstore has always been here, and I hope it will always be here because of exactly events like this. So Nell and the team who made this possible, thank you very much. I hope you will also all go out and buy this book because it's incredibly, as Publishers Weekly said, lucid, well-reasoned, and deeply important in our time. And because Judge Rakoff has done something quite extraordinary here, which is he's taken on some of the deepest and most intractable issues in our criminal justice system and even legal system, even more broadly, but written it in a way that not just wonky law professors like me, but ordinary citizens who care deeply about our country and our world can engage with, understand, and learn from. And as I told the judge, I'm going to try to restrain my inner wonky law professor and engage him in a way that I think he wrote this book, which is to try to really spark a debate about some of the most important issues of our time. And before I get into the meat of the book, and there's so much meat to get into, I want to start actually with the question of why you wrote this book, Judge. It's actually not that common for judges to be heard at all outside of, let's call it, their official or ceremonial capacities. And when they do write, it's especially not common for them to be pretty forthright about what they think and when they think the other judges have gotten it wrong. And I'll say that it's particularly unusual for a judge who's in a district court, as you are, to say such things about, let's say, the Court of Appeals or the Supreme Court of the United States. So I wonder if you might just say a few words about what caused you to write this book and what was your intent when you wrote it.
So thank you very much, David. And I also want to thank the Harvard Bookstore for putting together this program. And I want to thank David for his very kind introduction. I'm very glad that my wife of 45 years is not in this room with me right now because she would demand rebuttal time. But the reason I wrote this book was my growing concern and, frankly, at times outrage at what I was seeing in my court, in the legal system, in my colleagues' courts, and in our society generally. The judicial canons of ethics, they're called the Code of Conduct for Judges, in Canon 4 says that judges should write about problems with the administration of justice, and the commentary even encourages judges to do that. But as you correctly said, most judges are a little hesitant about that, and I was hesitant for the first 14 years or so that I was on the bench. But finally, what I was seeing and what I was hearing just got to me, and I felt these are problems that may not be as well known to the public as they should be. They will not be fixed until the public knows about them. And so I ought to start saying something about it. I did that originally in articles in the New York Review of Books, and now in the book that I've written. And I think, frankly, my timing was propitious because I think we are at a point in our nation's history when we can undertake some changes. So I am hopeful that this book will lead to some of the changes I recommend.
Well, Judge, your timing is not just propitious, but so critically important because so many of the issues that you actually addressed, sometimes in essays that go back a few years, have really come to the forefront. And the book, as I read it, and for those of you when you do read it, although it comes from a series of essays, it also has a very fluid and coherent arc that takes you from the way the criminal justice system interacts with ordinary citizens to the way in which we think about corporate crimes and financial frauds, to the way in which we think about the interaction between the courts and the government, to the most fundamental problem of how do people get access to the law or the courts altogether. And I want to have a chance to kind of touch on all of those in our time together here. So let's start at the beginning, because you start with something. Again, when you wrote about it, Judge, and I am a consumer of your reviews in the New York Review of Books, before it became as pressing an issue as it is now, and that's the issue of mass incarceration. And you write very deeply and quite frankly, poignantly about what this problem is doing to our justice system. And I wonder if you might say a few words about your argument there, but also why you chose to begin the book there.
I begin the book with mass incarceration because it is, in my view, a source of national shame. When I was growing up, we used to say the United States is the leader of the free world. Well, now we are the leader of the unfree world, in the sense that we lock up more people than any other country in the world by a substantial margin. In fact, 25% of all the people who are in jail and prison in the world are in jail and prison in the United States. That was not always so. In fact, between 1980 and 2000, when this change came about, the number of people in jails and prisons in the United States increased by 500%. And now, since 2000, almost every year, not almost every year without exception, more than 2 million people have been locked up in the United States. A huge number. And who are these people? They are mostly young men of color between the ages of 18 and 34. That's 60% of the population. They are mostly poor people. That's like 80% of the entire population of people in jail. And their incarceration, often for modest crimes, is frequently because of laws that were passed by Congress in the states in the period between 1980 and 2000, are for very long periods of time. Something like 19% of all those people are there for life, mandatory life imprisonment. And this mass incarceration, in my view, is having a ruinous effect on large segments of our society. By the way, it's also very expensive. It costs about $180 billion a year to keep all these people in prison. But the young men, mostly, who are the people being locked up, their lives are being ruined in many cases. They will never be able to get a good job. They will never be able, even when they're released, to resume any kind of activity like the ones they had before. Their families are being devastated. Their families are being deprived of male leadership at an important point when typically they have young children. Their communities are being devastated, both in having so many people from the neighborhood in prison, and also the effects on the economy of many of these neighborhoods. So we are paying a huge price. And the irony is that crime rates have, with just one exception, decreased every year since the year 2000. They're now at levels that we hadn't seen since the early 60s. The one exception is there has been an increase in certain types of crime during the pandemic. This is, in my view, a temporary situation brought on by the huge stresses that we all feel. But with that exception, crime rates have gone steadily down, but the incarceration rate hasn't gone down. We're locking up more people for longer than ever before.
So, Judge, you write so movingly about this, and it connects to the next chapter and also back to my first question, because what you make clear is this is a systemic problem. And, there are systemic issues that have to do with societal issues, but there are also systemic issues in our criminal justice system. And one that you single out for particular scrutiny is the guilty plea. And you talk a lot about how in our system, more than almost any other in comparable Western, democracy, that we proceed through guilty pleas. And in fact, the number of trials, as you point out, has been declining quite precipitously. And you then talk about what we might be able to do about that, which is a more, I'm going to use this word carefully, activist role for the judge, or perhaps for the judiciary, because maybe it's not the judge, maybe it's a magistrate, someone who looks behind the power of the prosecutor. Because as you say, the reason we have so much guilty pleas is because of the power of the prosecutors for the power of defense. And I wonder if you might just talk a little bit about that and how we might square that with where I started from, which is this image of the judge as, kind of to quote the Chief Justice, who you talk about later on, who is our alum from Harvard Law School, you and I are both, as neutral arbitrator, balls and strikes, umpire, somebody who's not involved in the fray at all.
So talk about images. The image that we all have of the criminal justice system, which was also the image that the founding fathers had and that they embodied in the Constitution, was of people who are accused of crime being given their day in court, protected by the presumption of innocence, protected by the government's requirement to prove guilt beyond a reasonable doubt. And those charges would be presented to a jury of their peers, who would then have to unanimously decide whether the defendant was guilty or innocent. That is an almost total myth in terms of the way the system operates today. Since the laws that I'm about to talk about came into effect in the late 20th century, the number of people who go to trial has steadily decreased, and now it's only 3%. Only 3% of all the people charged with crimes go to trial. What happens to the other 97%? They enter into initially secret plea bargains, hammered out behind closed doors in the prosecutor's office. And the judge is largely reduced by law to just rubber stamping that. The reason this came about was that there were rising crime rates in the late part of the 20th century, beginning around 1960 or so. And in reaction to that, the legislatures, not just Congress, but the state legislatures as well, passed very draconian laws that created mandatory minimums. For example, in federal drug cases, the mandatory minimums can range up to 20 years, and if a gun was involved, it can range up to 45 years. And the judge has to impose that sentence, has no choice. And then there were career offender statutes that said if you committed 3 felonies, even if some of them were minor, you would be sentenced to mandatory life imprisonment. And then there were guidelines that are now discretionary, but for the first 15 years were mandatory, but even now are so draconian and so severe that they have a clear effect on what judges feel comfortable in imposing in their sentences. So the result of that was that even someone who was innocent, let alone someone who only committed a minor crime, felt, gee, if I go to trial, I may face 45 years mandatory. I may face life imprisonment. And so I got to get my lawyer to get me a plea bargain. And that is exactly what happened. And so that's why 97% of the cases are plea bargain. And moreover, the plea bargain in effect determines the sentence, because the prosecutor will say, fine, I won't give you a 20-year count. You were less culpable than some people, and you're willing to plea bargain right away and save me the time of having to prepare for trial. So I'll give you a 5-year count. So that person still gets 5 years mandatory in prison. Moreover, the pressure is so severe that something as much as 10% of the people who plead guilty are actually factually innocent. And we know that from exonerations. There have been now, starting with the Innocence Project DNA exonerations, and now other exonerations approved by the court as well, at least 2,400 people who have been exonerated in the last couple of decades. And of those, 10% pled guilty to crimes that they didn't commit at all. So this shows you how severe the pressure is. So the biggest improvement could be to do away with these laws, to take away laws that have mandatory minimums, to take away laws that have career offenders. That would be the single most improvement. Short of that, though, it seems to me that if judges want to have any role in the criminal justice system, they shouldn't confine themselves to approving after the fact these 97% of guilty pleas. They should involve themselves at an earlier stage, right after the charge comes down, whether through an indictment or complaint, and meet separately with the prosecutor and the defense counsel and get a much better idea of what's really going on, and then make recommendations. They would not be binding. They would just be suggestions, but my guess is that they would be frequently persuasive. And judges in the federal system are precluded by law from doing that now. But in some of the states, it's been tried, notably Connecticut, with considerable success. And I think it would have a ameliorative effect, not as great as my preferred solution of doing away with mandatory minimums, but still a positive effect.
So, Judge, that's a perfect segue to the next topic, because while in the individual crime world, there are mandatory minimums and very little discretion by judges, and an enormous set of structural and institutional motivations towards criminal punishment and jail time for individuals. On the corporate side, in the civil, both civilly and criminal, the incentives work in almost exactly the opposite direction, as you point out. So you have one chapter about how no one was held criminally responsible, roughly speaking, certainly no one of any senior status, for the financial meltdown of the global financial crisis, notwithstanding the fact that almost everybody agrees that there was fraud involved, and fraud at a billions, if not trillions of dollars of scale. And instead, the focus has been on what you call prosecutions of corporate entities, not individuals, which in turn are not resolved by putting the corporation in jail, since it's not quite clear what that would mean, but instead through a process of, let's just call it what it is, rehabilitation, parole, psychiatric counseling, only it's called compliance reviews, structures of accountability, whatever. Talk a little bit about the
Yeah.
disjunction between these two worlds as you set out in the book.
So again, the difference between the paper laws and the reality could not be more stark. On paper, the law applies equally to rich and poor. I take an oath, as does every federal judge, when I first become a judge, to apply justice equally to rich and poor. But in practice, we have one law for the rich, a very um, easy law with very few sanctions, and one law for the poor, those 2 million plus people who go to prison. How did this come about? It wasn't always the case, any more than mass incarceration was always the case. When I was a federal prosecutor, I was in charge of business fraud prosecutions in the Southern District of New York. And the rule was, let's always try to find the highest level individual who committed this crime. That's the person who really made the crime happen. That's the person who could have stopped it. That's the person who should go to jail for what were often massive financial crimes. And the result of that was that the head of Enron, the CEO of Enron went to jail, the CEO of WorldCom went to jail. In the savings and loans scandal, no fewer than 800 individuals went to jail, right up to the #1 guy, Charles Keating. And this was standard Justice Department policy throughout that period. Beginning around 2005 or so, it began to change. And a number of reasons led to that. But I think the most obvious reason was that it was so much easier to go after a company. Under federal law, under a doctrine, forgive me for using a technical term, respondeat superior, the crimes of even a very low level person done on behalf of a company are imputed all the way to the company itself. So if you have a regional accountant who fixes the books in his little area and is caught, that immediately makes the company liable for that fraud as well. And the result is that it's a piece of cake to go after the company. By contrast, it's always been difficult to go after high-level individuals, but the way it was always done, frankly, is the same way you go after mob bosses. You start at the low level, the guy who in the mob case pulled the trigger, or in the case of financial fraud, made the affirmative misrepresentations and lies. You convict that person, you flip that person, and you go up the chain, being careful at all times to make sure you have corroborating evidence for whatever that person is saying. But that can take 2, 3, 4 years. There's no guarantee when you assign someone to investigate that case that it's going to come out positively in terms of going all the way up the chain. So it was discovered in the early 2000s that you could achieve a politically viable alternative by going after companies and saying, well, you're stuck, fellas, you're a low-level accountant committed a crime, so we got you. Now, there was a problem here because of the collateral consequences. If you went after a company and you imposed a big fine, $1 billion or $2 billion, which usually, frankly, was only a small portion of what the company had made from the fraud. So it was just, from the company's standpoint, a cost of doing business. But it sounded to the public like a lot of money. But that money would be paid by the shareholders ultimately, who usually had nothing to do with the crime. So that was a problem. In some cases also, it would mean that the company would be forced out of business. For example, pharmaceutical companies. I'm sorry to have to mention this, but Pfizer committed many, many crimes that were caught. But if you had prosecuted and gotten a guilty plea from Pfizer, it would have been forced out of business, which, needless to say, none of us, even without the benefit of hindsight, would have wanted to see happen. So the prosecutors came up with the notion of a deferred prosecution. We will enter into an agreement with you whereby you will agree that if you don't keep your nose clean for the next 3 years, you will be prosecuted. In the meantime, you will pay a fine in advance, and you will impose some compliance measures that theoretically will prevent you from committing this crime in the future. And then after 3 years, if no problems have emerged, we will drop the prosecution and you will not, in fact, be prosecuted. So that was called deferred prosecutions, and they became commonplace, several hundred in just the last 2 decades. The definitive study of those has been done by Professor Brandon Garrett of Duke Law School. And what he found was they didn't work, that there was a high rate of recidivism. And why not? The money, as I said, was just a cost of doing business. The compliance measures were usually looked at as something imposed from without, and not really part of corporate culture within the company. And so the temptations to commit deeds in too many cases were still there. I want to emphasize that most businessmen are honest, but there are enough, unfortunately, dishonest business people, often at high levels, who are attracted by the opportunity to make billions of dollars, which is what these frauds typically involve. So instead of spending 3 or 4 years going after the individuals, the people who actually committed the crimes, they spent 6 months going after the companies, and they had them, it was an easy case to make because of respondeat superior. And the companies entered into deferred prosecution agreements that had little effect. Whereas in my view, if you really want to deter executives from committing these crimes, you have to send those executives who did commit those crimes to prison. And so you have the irony: people who orchestrated billion-dollar crimes didn't even get charged. And everyday folks who were poor and who were led to commit much less substantial crimes went to prison for long periods of time.
So, Judge, that's distressing enough, but the last section of the book really raises even more fundamental problems, because in addition to what you very persuasively argue is a lack of sufficient oversight over the marketplace, you then argue that there is a lack of sufficient oversight by the courts over the government. And you do so actually by taking on one of the great heroes of every law professor and every law student, which is the first Chief Justice, John Marshall, and Marbury versus Madison. I'm not going to geek out on that too much, but I think it would be, I'd love to hear you talk a little bit about your argument that actually, unlike what many people argue, and Judge, you must know this, that there's too much oversight by the judiciary over the legislative and the executive branch, particularly the executive branch is what you call out. You argue that there's not enough oversight. And I wonder if you talk a little bit about that argument.
Yes. So by the way, I momentarily lost your picture, but can you see me still?
I could see you, but you don't need to see. You're the one everybody wants.
I don't need, as long as
Nell,
you can hear and see me, that's fine. And then I will, as I said before we began our program, one of the requirements of being a federal judge is to be technologically incompetent, and I qualify for that completely.
Okay.
So
I can still hear and see both of you.
Well, that's fine. And
thanks, Nell.
So we have another huge problem in this country, which is that everyday people, people of just middle class and working class people, don't have access to the courts anymore. Here are some of the statistics, and these are compiled by the state courts that collectively compile these for all 50 states. 20 years ago, almost any individual who was named in a lawsuit, either as a plaintiff bringing a lawsuit or a defendant who was being brought into a lawsuit, had a lawyer. Now, the average in all the states collectively is that 2/3 of individual defendants and plaintiffs have no lawyer, 2/3. Moreover, in the two courts where most people get involved, housing court and family court, in some states, the figure is as high as 90%. So people have lost their access to the courts. Why is this? Partly it's because lawyers have become extremely expensive. Partly it's because even aside from the lawyers, the cost of conducting a lawsuit has become very expensive. Partly it's because the groups like unions that used to supply lawyers to their members have declined. Unions are now something like only 7% of the private workforce. Partly it's because with the total approval of the Supreme Court, employers and producers and retailers are able to require anyone who purchases or wants to work for them to agree to arbitration, to have any disputes decided not by a judge and a jury, but by an arbitrator who's not bound by the rules of law and who is paid for by the company, and they have no choice. Partly it's because a conservative Supreme Court has been very against class actions, which were one of the great innovations in the American legal system that allowed people who had small claims that were too small to make them want to go to court themselves because it would be too expensive. They could collectively bring an action, but there has been considerable judicial hostility, particularly at the Supreme Court level, to class actions. Partly it's because many cases are now referred to administrative agencies, both state and federal. And the federal court has said that they will be given special deference, the decisions made by administrative agencies. So I could go on and on. It's no one cause, but the overall effect leads to those terrible statistics that I mentioned before. And frankly, everyday people just don't go to court anymore, except when they're forced. And when they're forced, they go by themselves without a lawyer. And the last thing I would say is that the statistics are also overwhelming, that when you do have a lawyer, you do much, much better than when you don't. So this has made a real practical difference.
So Nell, I'm going to ask you to come back on in a second. I'm going to ask the judge one more question, which really builds on this. And I warned the judge I was going to ask him this. It builds on your book in part, but it's also beyond the book, which is a lot of the book we haven't yet talked about is about the relationship between technology and law. And you have a very trenchant critique of what I would call the Csification of law, meaning the way in which people think that scientific techniques, whether those are hair and fiber, or even fingerprints, or even old-fashioned eyewitness identification, has been flawed. On the other hand, you point out that DNA evidence has been one of the most important features to exonerate the innocent. kind of moving that into the access to justice world. The question is whether we'll ever solve the access to justice problem by trying to give everyone a lawyer in a world in which, as you say, lawyers are expensive, legal education is expensive. You know, your brother is a law professor with me. And where people are now—
I usually refer to him as my smarter younger brother.
Well, as I told you, we refer to him as Todd the God. So, a lot of people are looking—
I'm not touching that because judges are not involved in religious disputes.
Okay, fair enough. A lot of people are looking towards artificial intelligence. They're looking towards, smart DIY tools, point and click. We've seen an explosion around legal technology. And I wonder how you think about that, both with respect to access to justice, but now coming back to the core ideas of the justice system. Is the problem with technology it's just not good enough? What happens if it got really good? Would we be happy to take human beings out of the justice system? So I guess that's the question that's the big question I'd like you to think about, and then we'll get to the questions in the audience.
So you're very interestingly bringing two different themes together. Other than DNA evidence, a great deal of forensic science has been shown to be very defective. Things like bite marks, things like microscopic hair analysis. In fact, the FBI, after slowly coming to the realization that its hair analysis was not really good, did a study of 3,000 cases in which its own experts had testified that there was a match between the hair found at the scene of the crime and the hair of the defendant. And they concluded that that testimony was either completely wrong or at least substantially exaggerated in 95% of those cases, an unbelievable number of cases. So a lot of that evidence is very shaky. There's a worse problem, which is with eyewitness testimony for reasons that go to the frailties of human perception and memory and probably cannot be easily fixed. Eyewitness testimony is frequently inaccurate. In fact, the Innocence Project, in the now 365 cases where they have proven that the person who was convicted, in fact, was factually innocent, proven it using DNA. In 70% of those cases, there was a witness who took the stand and said, yes, I saw the defendant commit the crime. And those people weren't lying. They just had real serious and mostly unconscious problems in how they were able to perceive and remember events that they had seen only briefly in most cases. But the bigger problem that you're linking to all that is the problem of how are we going to deal with all these problems when people can't afford, they can't afford a lawyer, let alone an expert in eyewitness identification or bite mark testimony. I don't have a perfect solution there, but I have a couple of suggestions. One, which is already, of course, ongoing, and that you sort of alluded to, is online legal services. But that can only go so far. They do, in my view, a very helpful job in things like drafting simple contracts, preparing simple wills, and things like that. But if you have a court problem, they're not going to be available. Another solution, though, that is just beginning to take off, and only in 1 or 2 states, is the legal equivalent of a nurse practitioner. These days when you go to a doctor's office, you do get to see the doctor. He'll wave and say, how you feeling? And I shouldn't be so cavalier. My father was a doctor and it's a great profession. But a lot of your time will be spent with nurse practitioners who do the job very effectively, but charge one small portion of what the doctor charges. Um, and where you don't have insurance, as you don't in most legal situations, that's even more important. The doctor is charging the insurance company, but here in the legal situation, it's the client is being charged. So I think a very substantial reform would be the creation of a corps of legal technicians who would go to law school for maybe a year. Uh, some people would say that's all you need, though I won't ask you to comment on that. Uh, and then would be apprenticed to a similar person for maybe another year, and then would take a certification exam, and then could go into court in all but the most specialized and complicated cases and represent the person. When I was at Harvard Law School, I was a member of something called the Legal Aid Society and the Legal Aid Bureau. And under a Massachusetts decision that dates back to, I think, the 19th century, students can represent people in court in civil cases before the Massachusetts courts. And that's what I did. Now, was I very good? No, but I was frankly a lot better than my client would have been. And so that shows what can be done. By the way, that is still the law, and I know that because of the wonderful motion picture Legally Blonde, where the hero L comes into court and represents and gets her client off, even though she's just a student at the law school. So anyway, bottom line, I think there could be a huge increase. There are a few states that have experimented with this, but I think it could be made much more important, much more significant, and be one way of reducing the problem of access to justice.
Well, Judge, that is, your openness to that is just yet another reason why we're so grateful to have you thinking about and talking about these issues. Nell, do you want to appear and ask a question from the audience for the judge?
Sure, happy to. And please, folks, start sending in your questions if you have one. We have a few minutes, so please feel free. Our first one, coming in from Stephen Pugh, asks, is the criminal justice system actually underfunded and lacking in resources? Has it matched population growth, or is, lacking in people, facilities, proper experts? Is it just a question of like allocation, I guess, would be sort of my tag onto that. But
well, more money would not solve most of the problems I've referred to. For example, there's been this huge decline in the number of jury trials in both the state and federal system. The federal judges were more than fully capable of handling the number of trials they used to have before this decline occurred. In fact, most of my colleagues complained to me, we don't have enough trials. We wish we had more trials.
Yeah.
State courts are underfunded, and they are in need of greater numbers of judges and greater numbers of staff as well. And that would be helpful, but I don't think that's the true heart of the problems I've identified. I will add one little sidelight that to know. One place where you really could use more funding is for criminal justice experts. And this is even for cases that just plead guilty or enter into plea bargains. If the evidence is forensic evidence and the defense lawyer can't hire a expert to expose for him all the possible problems with that forensic evidence, there's nothing he can do about it in many states because the funding is not available. And that makes a huge difference. Lawyers are not scientists. They need the help of those experts.
Mm-hmm. And have a question. From an anonymous attendee. This seems like a difficult and potentially risky book for you to write as a judge. Did anyone discourage you from writing it?
So we can go back to where I started, Judge. Tell us about that.
So the nice and wonderful thing about being a federal judge is you have lifetime tenure. The state judges, again, are not in as good a position. In most states, they have to run for re-election every once in a while, and that can make them a little more hesitant to take on controversial topics, either in their decisions or elsewhere. Federal judges, though, have this considerable greater freedom. So far, all my colleagues have been very supportive of my book, although I know from common sense that what they're saying to my face may not be what they're saying behind my back. But nevertheless, they've been very supportive.
Good. We have an interesting question from someone suggesting we have Ishan Shivakumar asking, perhaps one of the reasons why defendants would prefer a plea is because they do not have faith in an unbiased jury. Do you think juries, sort of suggesting of the possibility, like, should juries be abolished, and offering the example that India stopped jury trials in the 1970s?
So my own experience is that juries are very fair and very unbiased, but that's not the way they're perceived. And so that's a real problem. Most people, particularly in the criminal justice system, are very cynical about the system as a whole, and that includes their view of juries. And that's another reason why innocent people plead guilty, because they think they won't get a fair shake from a jury. It's really not true, in my view, but it is part of this more deep-seated cynicism. There's a racial aspect to this, too, that can't be ignored. I've had many cases where the defendant, who's a person of color, has said, I want a new lawyer. And when you really press, why do you want a new lawyer? Because the appointed lawyer is often terrific. It's because they don't have a rapport with the lawyer based on the fact that the lawyer is white and they are black. And so it's very important that we have more lawyers of color in the system, to, especially in the criminal justice system, to have that kind of rapport. And that carries over, of course, to the composition of the jury as well. Although thanks to here, the Supreme Court did something very good, the Batson decision. Most juries now are racially mixed.
And we have a new question about someone asking about what do you think about, or rather, what does the country, I guess, do? It says, what do we do about law enforcement testifying? And sort of suggesting that this is doing a lot of damage to have law enforcement testify. Has that been your experience?
I'm not sure I understand why
so let me put
a problem. Yeah.
Let me put a spin on it, Judge, because just having read your book, you talk a lot about why prosecutors believe forensic evidence, even though there's lots and lots of evidence to say that that isn't likely to be very accurate. And it's because of what we might call confirmation bias. That is, and I take the question maybe to be, look, the police picked this person up, they arrested them, maybe on the basis of eyewitness testimony or somebody, a tip or something. And now when they're testifying, is there a worry that they will be invested in proving their own actions right?
Okay.
And if we add a kind of racial dimension to this, which you raised before, I'm sorry, go ahead, Nell.
No, sorry, I just want to jump in because I see, yeah, I was misreading it. It was sort of a portmanteau that I'm not familiar with this term testifying. So I guess,
Yes.
yeah, law enforcement.
I think the worry is there, that police will back each other up, and how do you deal with that as a judge?
Yeah.
This is out there in the world.
So, I mean, first of all, just as a tactical matter, when a case actually goes to trial, as opposed to hearings before trial, the hearsay rule applies. And so typically police are not part of that, or they're only minor parts of the testimony because it's someone who, like an eyewitness, who can give non-hearsay testimony about what they observed about the crime. But I don't mean to minimize a lot of what goes on in the criminal justice system is determined by, first, what the prosecutor hears, because as I indicated, the prosecutor has most of the ultimate power in a guilty plea system. And what they're hearing is almost exclusively from one side, from the police. Now, in my view, just like I believe and think it's true that most businessmen are honest, but there are some rotten apples, ditto the police. But a perfectly honest police will still suffer from what Professor Wilkins just referred to as confirmation bias. Mm-hmm. They've decided, I'm pretty sure this guy is the one who did the crime, and that will influence both what they look at. They won't look at other suspects who may be actually the persons who committed the crime, and even more so what they report to the prosecutor. And the prosecutor is only hearing until the very end of the negotiation just that one side. So that is a serious problem. I have a solution that I think will not be adopted, I'm sorry to say, in the United States, but it is in effect already in England. And my solution is that every prosecutor has to serve 6 months out of every 3 years as a defense lawyer in another district, so there would be no conflict, representing indigent defendants in that other district. And this would lead to prosecutors who had a more balanced view and who would also be more skeptical of what they're receiving and would ask hard questions of the police that they don't ask now. In England, criminal cases are tried by barristers, and these are professional trial lawyers who literally can be the prosecutor in one case and in the very next case, the defense lawyer. And that gives them a balance that I think could be achieved here through the proposal I have. But I suspect that very few prosecutors' offices are going to support that approach.
Well, Judge, let me just say that that's a perfect note for us to end on, precisely because you are one of the rare judges who's willing to look at the judicial role, let's say from the outside in, and having had the great pleasure of getting to know you over many years and seeing you in many settings. That is a rare gift, and it's one that I think, again, I'm going to hold up the product, that those of you who are wise enough to go to the link that Nell's about to show you at the end of the chat for the book and buy the book, will see that it's a very fair-minded, even-handed, but from the outside in perspective on the criminal justice system, from someone who knows enough from the inside out to be able to comment on its strengths and weaknesses. And I think at a time in our history in which we tend to go to our corners, in which people don't speak to each other and they are in their own echo chamber, to have someone who is willing to model as a kind of self-reflection and argument both the internal and the external point of view is something we can all learn a tremendous amount from. So I want to thank you for giving me the opportunity not only to go out and get the book and read the book, but to engage with you in this dialogue, and for you giving of your very valuable time in the midst of a snowstorm, folks. You should know he's got to get home. So I promised him we would end early. Either Nell or Judge, any last comments that you want to say?
No, you are extremely kind, and I'm very flattered. And you know, I have ultimate confidence in the American people. They go down roads sometimes that are not the best, but they always come through in the end. That's been so satisfying to me. And I think once they understand the kinds of problems that in my little way I'm trying to bring to their attention, they will be very open to good solutions. So I want to thank everyone very much. And actually what I have to go do now is shovel snow, so I better get to it.
Nell?
Gentlemen, thank you both for this fantastic conversation. And as David mentioned, I have reposted the link from harvard.com. Please go there to learn more about and to purchase Why the Innocent Plead Guilty and the Guilty Go Free. And thank you so much to both of you. And on behalf of Harvard Bookstore and me beaming in here from Nashville, have a good night, everyone. Stay safe. Stay warm. Thank you.
Thank you. And
Good night.
shovel slowly, Judge. We need you. Bye-bye.